It was a prank that went terribly wrong. A high school lacrosse star is dead after what police say started as a late-night game of ding-dong ditch, the familiar prank where teens ring a doorbell and run away. According to investigators, the group of teenagers had been recording the stunt for TikTok when the homeowner mistook their game for a break-in. What was supposed to be a joke quickly turned deadly. Authorities say one teen is dead, another injured, and now the homeowner is behind bars, charged with murder. I'm Kennedi Walker, and I'll walk you through the details. Michael Bosworth Jr. had his whole life ahead of him. A senior at Massaponax High School in Virginia and a standout athlete, the 18-year-old was just weeks away from graduating. But instead of celebrating his diploma, his family is now preparing to lay him to rest. According to the Spotsylvania County Sheriff's Office, Bosworth was shot and killed early Saturday morning while attempting to film a TikTok prank. Deputies say the incident unfolded around 3 a.m. on May 3rd when a 911 call came in reporting that 3 individuals were allegedly trying to break into a home by kicking in the back door. The homeowner, identified as 27-year-old Tyler Butler, told investigators he believed he was being robbed. Butler allegedly opened fire on the teens, killing Bosworth and grazing another. In the immediate aftermath, Butler was not arrested. He told investigators he believed he was being robbed in the middle of the night and fired in self-defense. Under Virginia law, homeowners are not required to retreat if they believe they are facing an imminent threat, a legal protection more commonly known as stand your ground or no retreat law. The statute can give individuals the right to use force, including deadly force, if they reasonably fear for their safety. But that changed when police spoke with the 2 surviving teens. According to court documents obtained by 7 News, the teenagers told authorities they weren't attempting to break in or steal anything. Instead, they said they were taking part in a prank, Ding Dong Ditch, where they would ring doorbells and run away in hopes of the resident answering the door with no one there. The teens reportedly admitted to police that they had already filmed themselves pulling the prank at several homes that night and were planning to post the footage on TikTok as part of a social media trend. But when they knocked on Tyler Butler's door, the prank took a deadly turn. According to their statements, after ringing the bell, they ran to hide and were struck by bullets and met with gunfire. Both Michael Bosworth Jr. and one of his friends were shot. The 3rd teen wasn't harmed. Bosworth was rushed to Mary Washington Hospital, but later died. The 2nd teen was hospitalized with non-life-threatening injuries. Tyler Butler was arrested and charged with 2nd-degree murder, malicious wounding, and 2 counts of use of a firearm in the commission of a felony. And joining me to talk more about this is criminal defense attorney Diane Toscano. Diane, thank you so much for coming on today. Let's get right to it. At first, Tyler Butler was not arrested, and then he was. How can police justify this if he thought he was being robbed?
And that's a great question. This case is going to turn on whether or not a judge or a jury will find that the defendant felt that he was in reasonable imminent fear of bodily injury or death. So in Virginia, in order to justify deadly force, you have to believe that at that time in the present situation that you or your family are in imminent harm of death or serious bodily injury to justify that use of force. So I understand based on some of the reports that have come out that the police, I believe, have reviewed cell phone video footage from 2 of the individuals that were involved in this. So there must be something that the prosecution felt did not justify the force that was used in this case.
Why wasn't he arrested right away then? Because I know it took some time.
Because it is true. In Virginia, you do not have to leave your residence. If someone is breaking into your home, you do not have a duty to leave your home. However, you have a duty to only defend yourself to the extent necessary. So that force has to be in proportion to whatever harm you think at the time is coming your way. So initially, what he did is not illegal to shoot somebody if they are in fact breaking into your home and you fear that they are going to kill you.
But I guess, does it get a little, murky here when, what he thought was happening, especially because, according to reports, this happened around 3 o'clock in the morning. So most people are sleeping, they don't know what's going on, and they hear this noise. So can he say that, he thought it was force because he used that force because he thought he was scared since it was so late at night?
Most definitely. And I'm sure his defense attorney is going to present a defense that he woke up 3 a.m. in the morning. He hears what he thinks somebody is banging or coming through a door in his home. He doesn't know what's happening. So it's going to come down to those details. What transpired? What did he believe was happening when he grabbed his firearm? Where was the victim located when the victim was shot and killed? Were these boys running away from the home and they were shot and killed? That's going to be an important detail, in fact, that is going to have to come out, and the judge and jury is going to have to consider that. Or was the individual, when he was shot and killed, at the back door about to come into the home, or the garage door, or the front door? So the location of where the victim is going to be important, and what exactly the defendant thought was happening. Because in Virginia, just being afraid is not enough to justify shooting and killing somebody. There has to be that real fear that something is about to happen to your life or your family's life.
Why did prosecutors charge Tyler Butler with second-degree murder instead of manslaughter, since this is, not so cut and dry?
That's a great question. I'm sure they are going through the evidence they have right now. They are looking at whether or not this is some type of homicide and trying to decide, does this meet an involuntary manslaughter or voluntary manslaughter or second degree murder? So, right now, whatever the Commonwealth in Virginia has, the evidence, they feel there's enough probable cause. Doesn't mean 100% they can show this happened, but they feel there's enough that lends to the charge of a second degree. It doesn't mean that that's going to stay that way. I think certainly as the case develops, there could be other charges brought, or they could reduce it down, or things could happen. You just never know. Once people start coming forward, if there were any witnesses, in this day and age, most people have ring cameras or cameras on their garage doors or backyards. So I'm sure the prosecution and defense are trying to execute subpoenas, get that footage, be able to come up with exactly what happened at this house specifically.
What role does intent play in determining whether this is self-defense or murder?
So here, because it's second degree, he does not have to have the intent to commit. When you think about first degree, you're planning to kill someone. That's something where you have the thought to do so. In this case, it's a self-defense claim, is what the defendant's saying. He only got his gun. He only shot his gun because he felt like he had to defend himself. So that's why he doesn't have to have the intent to kill somebody. I don't think anyone's saying this defendant intended to kill someone at 3 a.m. that night. He didn't wake up thinking, I'm going to go shoot somebody. It sounds like he woke up, thought his house was being robbed, and then he ended up getting his firearm. And unfortunately, he's now facing second degree murder, and there's now a young man that's dead.
How long could Butler face in prison if convicted on all counts?
So I have right now, is he charged with just second degree murder? It looks like he has, I think, a malicious wounding as well.
Yes, he does.
So he's got the 40 years on the second degree murder. And then depending on how they charge him with the other charges, he'll have more time as well.
Could the teen's actions still be seen as trespassing?
Yes, I think, there certainly could be seen as trespassing. But right now we have a deceased individual. So I know the police are investigating, was this force necessary? Did it have to get to this extent? But yes, certainly those individuals at 3 a.m., I'm sure could be alleged to have been trespassing.
Right, because one of them did unfortunately pass away, but there are two surviving teens. Could they potentially face charges like trespassing or any other charges?
That's something that the prosecution will have to look at, and the prosecutor's office will have to decide whether to bring charges. I will tell you, typically with my experience in Virginia, and I started out 20 years ago as a prosecutor, and then I've done criminal defense and complex civil litigation since. But the prosecutors typically, at least in this area of Virginia, do not want to charge alleged victims when they're also proceeding with another defendant. So I don't know if they'll want to do that. That's something that the Commonwealth attorney himself or herself is going to have to decide. Are there charges that they should bring involving the other two individuals?
If you were Tyler Butler's defense attorney, would you or could you argue that, he reasonably feared for his life even if the teens were pranking? Like, how exactly would you lay out your case?
So I would immediately want to talk to my client. I would gather as much information as possible because we do know that the three individuals had cell phones because it's at least it's come out in reports that they were recording these what they were doing at these people's houses as a TikTok challenge and planning to actually post it on TikTok. So we know they're recording some of what they're doing. So I'd want to look at where was the phone? Was the phone in his hand when he was shot and killed? Was he facing towards the home? Did the defendant think that the victim had or the deceased had a gun in his hand? What did he think he was doing? Were there words exchanged? I don't know if they said anything to each other. So the details are going to matter because, again, it's going to come down to whether or not the defendant felt that he was in fear of being seriously injured by the deceased, or possibly that the deceased had a gun and was going to shoot him. And again, as you said, he woke up at 3 a.m. He doesn't know this is a TikTok challenge prank. He doesn't know what's going on. What's been reported is he thought that somebody was trying to rob him and burglarize his home.
And you just touched on it, the it being 3 a.m. How much weight do courts give to the time of the night when considering the self-defense claims as well?
That's an important fact for the trier to consider, is the time. It's we'd want to know, what was the defendant doing when this happened? Was he in fact asleep? Was he woken up in the middle of the night? Because that is alarming. I'm sure a jury or a judge is going to have to consider, what would a reasonable person think is happening at that time. So all of the details are going to be important because, again, if these kids are running through the backyard away from the home down the street and he shoots them, that's going to be very difficult to prove that that was in fact justified. I think then that is a stronger case for the prosecution. But if the victims are right, the deceased is right there at the home near a door, has his phone in his hand, words are being exchanged, all of that's going to come into play as to what somebody would think was about to happen in that situation.
Well, I guess how would that, be proved? I know, just reading the documents, they mentioned that there were some things where the kids did have video of them, allegedly doing it to other homes. But if they don't have video of them doing it to Tyler Butler's home, how can that be proven? Like, if they did run away or how far away they were when he did shoot them?
In that situation, I'm sure the attorney who's representing Tyler is going to talk about whether or not Tyler should testify. Each person has a constitutional right to testify or not. You do not have to testify in a case, and a judge and a jury are not supposed to consider whether or not a defendant testifies. That's their right. But in this situation, it's going to be important to hear from the defendant to understand, what did he think was happening at that time when he made the decision to point a gun at somebody and shoot them. So I think that's going to be important. I know there was a neighbor, it had been reported that there was a neighbor who said these kids did not just ring the doorbell and run. I think he thought they were kicking in his garage door. So that person may be important to testify on behalf of the defense. I'm sure the cell phone video that was provided by one of the kids, I think, shows them ringing a doorbell. Supposedly, that's what's been reported. Again, I haven't seen any of this. That would be important for the prosecution if, in fact, they're going to allege, okay, they're ringing doorbells and running away. That's very different than banging down a garage door and someone thinking that they're about to come in their home.
Well, hypothetically, let's say they were, because I know that's a part of the initial statements that Mr. Butler gave to police. Let's say they were kicking the door or they were kicking in the garage. But if they ran away afterwards, after kicking, is that where he kind of gets in trouble? Because yes, they did kick in the door allegedly, or yes, they did kick in the garage, but by the time you came outside, they may have been gone, or maybe they were running away.
Yes, because again, the force that you use has to be in proportion to the harm that you're feeling. So if somebody's destroying your property, that's horrible. That's a crime. That's not good. But that doesn't justify you pointing a gun and shooting at somebody if they're just harming the property and running away. So that's going to be a key fact in the case, a key piece of evidence, I should say, in the case as to whether or not they were running away from the home when he took out the gun and shot them, or whether they were coming into the house at that time.
How important is the 911 call in Butler's initial statements?
That's going to be very important because, as a trier of fact, you're trying to look at the subjective intent, right? You're looking at what would a reasonable person in that situation feel was happening. Are they in imminent harm for their safety, for their life at that time? So having a 911 call is helpful because that's showing you what his present sense was at that time as he's making this phone call, what he thinks is happening. All of that is going to be an important piece of evidence in front of a judge and a jury when they're trying to decide, was this force justified? To have deadly force, you have to be justified to use that deadly force.
And regarding the prosecution, I know you mentioned something earlier that in a lot of instances, the prosecution doesn't really like to charge the victims in cases as well. But with the situation like this one, where, like we mentioned, no one just randomly, a normal person doesn't just randomly wake up at 3 a.m. and think, oh, wow, I want to kill someone. With the situation like this, will the prosecution, I'm just trying to figure out, will those teens get any type of, discipline? Now, I understand one of them is deceased, and that's terrible as well. But just how does that go unnoticed?
It's difficult because when I said, and it's hard, I'm saying victims, but to this case, it's hard to know who, it's to each person to decide who the victim is, I think, in this situation, right? But looking at these two kids who thankfully are still living, they are going to most likely be witnesses in the prosecution's case. So they're going to have to call those individuals to testify against the defendant because, as you said, how do we know whether they rang the doorbell and were running away or whether they were appearing to come into the home or what was being said? So it's going to be important for the individuals that were there at that time to testify to exactly what they were doing. So to charge them with a criminal charge and then to also have them as your witness can also pose a conflict for the Commonwealth Attorney's Office. Doesn't mean they're not going to do it. They do these cases where they'll have a different jurisdiction prosecute one of the witnesses so that way the jurisdiction that's prosecuting the defendant is also not prosecuting their witnesses, but they can have another jurisdiction step in and do that. But that's a lot goes into that as to what they should do and what they're going to do regarding bringing charges against the other two kids that were involved.
And let's get into the potential forensic evidence. Like could the forensic evidence, like where the teens were shot or bullet trajectories, make or break the case?
I think so, yes, because again, we need to know where these kids were at the time that the defendant shot two of them. Because as I said, if the kids have their backs towards the defendant and are clearly running away, leaving the premises, I think it's going to be difficult for a judge or jury to find the defendant not guilty if that's the facts, because then that that doesn't justify a killing. That doesn't give you the right to use that type of force if those individuals are fleeing and leaving the property. But again, if the student, the deceased kid, is facing him when he's shot and he has something in his hand, and depending on what the testimony is, you look at that subjective intent. You look at what would a reasonable person feel was happening at that time. Were they really in fear of being shot or hurt?
And will the fact that Butler potentially fired multiple shots come into play legally as well? We know that the deceased victim was shot. We also know that another juvenile was grazed, so it can be assumed that he potentially fired several shots. Will that matter?
It will. I think it will matter because again, if these individuals who allegedly, are trying to break in or rob him, if they are running from the property prior to him shooting or while he's shooting, that's an important detail. So depending on where they are and looking at why he shot that many times is going to be important. We have one person that's deceased, but we know there were two other individuals involved in this. So it's important to know where were the three individuals. Is the defendant going to say one or two of them were rushing at him, running towards him as he's trying to shoot them? Or is the evidence going to be that they weren't even, within 20 feet of him, and he was safe in his home and they're outside. So it's all going to come down to what exactly was happening and what the defendant thought was happening at that time.
Absolutely. And, what message does this case send about prank culture and social media trends?
Well, I hope that people are paying attention to this case, especially young people, especially these two individuals who thankfully are alive and went through this experience. Hopefully, this is going to be a platform to try to share to other kids that even something that seems like it's not a big deal, it's a prank. What they're alleging to do is a TikTok challenge with ringing a doorbell and running away. That doesn't seem like it's something that would ever lead to this. But you have to realize that you don't know what the person in the home has. You don't know whose doorbell you're ringing. You don't know what they're thinking. It's 3 a.m. I'm hoping that young people will realize that it's not worth it to do this TikTok challenge or something this stupid, and end up in a situation where now you have a defendant, a homeowner charged with second-degree murder, and you have another individual who is about to graduate high school, live his life, and he's now dead.
Is there any legal liability for TikTok or social media platforms when trends like this go wrong?
That's a great question. There's a lot of back and forth on when it rises to that level, if it's there. But certainly, it's a platform where people are allowed to post, different activities. It doesn't mean necessarily that TikTok's responsible for what happens with those activities, but that's a whole other area of law, and something that there are hard cases that have been litigated and that continue to be litigated about how to deal with TikTok and some of the outcomes that you get. Because, as you know, this isn't the first time we've heard of a TikTok challenge gone wrong and someone dying.
Absolutely. And before I let you go, what's next in the legal process and how soon could we see a trial?
So something like this could take 6 months to a year before it actually gets to a trial. Right now, the prosecution is going to continue to gather discovery that they will provide over to the defense. And when I say discovery, that's evidence, meaning statements, surveillance videos, ring cameras, anything that they can get, and that they have to disclose to the other side. And I know the defense will work on trying to get as many eyewitnesses or information that they can get as well. So they'll need at least, I would say, 6 months to prepare for a trial, but it could be even longer.
Well, this is something that we will be following very closely. Diane, thank you so much for coming on today.
Yes, of course. Thank you for having me.
As of this recording, Butler is being held in jail and was not given a bond. For Law and Crime, I'm Kennedi Walker.